Jennifer Martin is a partner at Jarrett Martin Law, LLP, an estate planning, mediation, and family law firm in Pleasanton, California. Her law practice focuses on estate planning, probate and trust administration, and probate litigation. Jennifer works with clients to develop comprehensive estate plans so that they can secure their family's financial futures. She also helps families dealing with inheritance disputes sort out their issues in litigation. Jennifer uses her Bachelor of Arts in Mathematics from UC Berkeley, go Bears. I'm not a Bears alumni, but I thought I'd put that in. And her JD from Rutgers University to navigate complicated financial issues and help clients figure out solutions that work for them. Jennifer enjoys sharing her knowledge about estate planning with organizations and groups across the Bay Area and the United States. Okay, Jennifer, let me admit.
Thank you.
And the floor is yours now.
Thank you so much for the great. Thank you so much for the kind introduction. So I've been asked to speak to your group today with a presentation that I call Estate Planning Fails. And specifically what it is a series of case studies about celebrity estate plans that went, shall we say, horribly wrong. And the goal is that we start talking about these issues, and I'm going to share as well some examples from my own practice for things that in your personal life, but also when you're dealing with clients, you can look out for these pitfalls and red flags, because all of us are in professions where we're advising clients. Many of us are dealing with planning issues, whether it's financial or otherwise, and estate planning is a big component of that. If you have questions, I don't mind, you can shove them in the chat box or ask them along the way, or if you want to hold them till the end, that's fine. I'm going to leave a lot of room for questions because people usually have questions about specific estate planning issues that I'm happy to answer. So, okay, let's get into the first case study. And this one is about Stieg Larsson. You may know him. He wrote the Girl with the Dragon Tattoo books. They were a very popular international book series, translated into many languages, including English, made into at least 2 movies, I believe, including one that was an English language movie, a very successful book series. And actually, sadly, I don't believe the first book was published in English until after the author had died. He had already passed away, I believe, before it was translated and published. So Mr. Larsson did not live in the US, but his situation is very similar to what would happen if he did live here and you had an identical circumstance happen to you. So he did not have an estate plan in place. He had nothing, no will, no trust, nothing in place. He did have a partner of over 32 years with whom he shared a life and a house and all those things, but they were not legally married. So she was not considered his spouse. You probably know that if you have a spouse, there are certain privileges in almost every jurisdiction a spouse has in terms of inheriting assets. Instead, what happened was his father and brother, from whom he was estranged, received everything because they were his closest living blood relatives. And that's exactly what would happen if you were to pass away in California without a will. Your closest living blood relatives would receive shares of your estate in a way that is set out by California statute. So I often tell clients that if you don't have an estate plan, well, you actually do have an estate plan, but your estate plan is that you're fine with what we call intestate succession. And you're fine with having to go to court, not you, but the person who decides to do it, having to go to court, opening a court case, having to identify relatives, having to endure what in our local counties can be at best an 18-month process before you can actually receive distributions from the estate. It's also a costly process. Attorneys, if you have one doing the estate for you, will charge what's called the statutory fee. And it's 4% of the first 100,000, 3% of the next 100,000, 2% of the next 800,000, and then 1% of the next up to 8 million. So for the first $9 million worth of the estate, you are dealing with quite a costly cost of administration for the attorney. An average estate in our local counties is usually in the region of something like $17,000 in attorney's fees. So because he didn't have a will, his estranged family got everything because they were the closest blood relatives. They did give his partner of 32 years the apartment where she had lived with Mr. Larsson for most of that time. But they crucially retained control over the rights to his IP. So his book series, they're the ones who made a lot of the decisions about licensing it to be made into movies. And crucially, they actually hired someone to write the completion of the series. The series was not finished when he passed away. And most of his friends and close acquaintances agree that he never would have wanted someone to be hired to complete his work. He wouldn't have wanted that. And if he had had a plan and left it in the hands of his partner, then presumably those things wouldn't have happened. So for those of us who enjoy his books, we're pleased that the series was completed, but that was not what he wanted. And at the end of the day, estate planning is about what the person who's doing the planning wants, even if it's not what the relatives want, or maybe always what is wise or desirable. So this is a really good example of not having a plan in place can be very costly and damaging to the estate. Speaking of which, let's talk about Prince, because he is a very interesting and very concerning example of what can happen when you have a good amount of property and no will. So he also did not have a will. He had no children and he wasn't married. So when he passed away, as you might imagine, when you're dealing with a multimillionaire, 45 people came forward and all claimed to be his heirs at law who were entitled to a portion of his estate. Now, he did actually have 6 siblings and half siblings, so they were the obvious group. In most states, including California, the blood relatives who are going to inherit from you if you pass away without a will, it's not your second cousin twice removed unless you don't have a single closer living relative. It's your parents if they're still alive. I'm sorry, your spouse if they're alive, your children if they're alive, or other descendants, grandchildren, great-grandchildren. Your parents if you don't have any of the other relatives. Then it goes through the line of your siblings and their descendants. And then if there's nobody in that line, you actually go back up to the grandparents and go across to your aunts and uncles and their descendants. So to get to some of these far-flung relatives, you have to go pretty far with not having a single living relative in any of those other classifications. So they narrowed it down to these 6 people, but they're still fighting. So he passed away several years ago. They're still in court. In 1 month alone, there were over $660,000 in attorney's fees that were charged to the estate. Now, obviously, he has a lot more property than most people. There's a lot more to fight about, but they opened the door by going to court, and that's always what happens. In fact, over this last summer, unfortunately, one of the heirs passed away, even though the state administration is not done. One of those heirs passed away. And the day before or the morning of his passing, he sold his rights to Prince's music catalog to a company that often purchases those rights. And he made a will leaving everything to an unrelated friend. So now 1/6 of that estate is owned by a person who had no connection to Prince, really, a person who was the beneficiary of somebody else's will. Additionally, because there were so many problems and the estate wasn't properly organized, the IRS has had their say. Obviously, the estate owed estate taxes, which we're going to talk more about in a minute. And because the professional executors who were hired, the IRS claims that they undervalued the estate. In January, they imposed an additional $32.4 million penalty, which was the estate taxes that they say were owed and the $6.4 million penalty for undervaluing the estate. So because there was no planning put in place and because he was well over the estate tax exemption limit, his estate owes money to the government, and now his estate owes a pretty hefty penalty. And they've had to set the matter for trial in tax court because obviously nobody's just going to turn around and give the IRS an additional $32.4 million without making absolutely sure that that's really owed. And these are some of the problems that my clients run into too. I don't have a client who's on the level of Prince. I don't think most of us will ever see a client who's at that level of wealth. But a lot of people in the Bay Area specifically have a lot of wealth. And if they aren't married, or if they're married, but they have multiple pieces of property, for example, they can easily be above the estate tax limit and they might not even know. I'll tell you, I have some clients right now, very, very nice, very hardworking people. They, over the past decade, several decades, have purchased a bunch of real property that they use as rental property in the Bay Area. As you might imagine, they purchased those properties for pretty low values, and those properties are now valued very highly because of their locations. They came to me to do a very minor amendment to their trust. And once we started talking about their property and what they had, quickly discovered that they may already be, as of today, over the estate tax exemption limit, and they had no idea. They never thought of themselves as being people who had to worry about that, because right now it's set at about $22 million for a married couple. Who needs to worry about that? Not most people, but they did. And it's because we all know the real estate market is booming right now. And so people do have to think about these things. So if they had not come to me, I'm not sure they ever would have realized that this might be a problem. Another thing to consider, right now, the estate tax exemption is very high. It is due to sunset in 2023. There is very little chance, as far as I understand, that it will stay at the over $11.5 million per person exemption that it currently sits at. It is very likely it is going to be decreased. Now, is it going to go back to when it was 500,000? Probably not. There does not seem to be the political will to do that either. But we may see it go back down to about the 5.5 million per person it was sitting at prior to the increase under the Trump administration. So these are real things. There will be clients. I have clients. There will be other clients who get caught if that number goes down, because frankly, in the Bay Area, if you own 3 pieces of real property, you might already be over the $5.5 million. You might be. They'll still have the combined exemption for a married couple, we presume, but we don't know definitively. But these are some of the issues that we have to look at, and we have to look at specifically because we do think that the next couple of years might be a time of change as to how we look at this. I will say there does not seem to be any current desire to impose a California estate tax. California does not have a state estate tax. Other states do. If you have clients with property back east, it is somewhat likely that they will have property in a state with a state tax. So for example, Massachusetts is one of the big ones that does have an estate tax. Their rules are a little bit confusing, and I'm not a Massachusetts attorney, so I certainly wouldn't presume to advise people about their laws specifically, but it is something important to look at, because under certain circumstances, they claim the right to use the total value of the estate, even if in Massachusetts, the property that you own is under the exemption limit. So that can be problematic. I think it largely depends on where you make your residence, but that is something that we always have to look at with clients who own properties in multiple jurisdictions. All right. Let's talk about James Gandolfini. So he did have a will. So at minimum, he had a will. That's great. But he was another person who didn't make a plan as his circumstances changed. And that's what we see a lot with clients who get stuck going into probate. A lot of times it's because their wealth increased and they did not realize that they needed to make changes because of that. So with him, he had an estate worth $70 million when he died. Again, most clients, they don't have an estate worth $70 million, but a lot of these things apply to them. So obviously, if he only had a will, he had no special tax preparation. They paid estate taxes. They paid estate taxes at a rate of 55%. They paid over $30 million in estate taxes. And that's what happens when you don't have those specialized structures in place. A lot of times now, we all know it, we have clients who get their estate plans done from LegalZoom, from other websites. They go to a document preparer. It's not wrong to do that. I'd rather somebody have something than have nothing. But when people have actual assets value to protect, having a will is not enough in California. In other jurisdictions, it may be fine. For example, I'm also admitted to the bar in New Jersey. In New Jersey, only the very wealthy have trusts. And the reason for that is when you go to deal with an estate, you go to a local attorney's office who's been delegated by the court for that region to have authority to accept wills. And you basically go into their office, you sit for 20 minutes with the will, they accept it as a valid will, and then you start the estate administration process largely without any court intervention or court contact. In California, by contrast, you file a petition to administer the estate. You have to produce the will. You have to notify everybody. You have to publish in the newspaper. You have to wait for your initial hearing. Once you get appointed, you have to marshal the assets of the estate, deal with any creditors. You'd have to do that even if you didn't have to go to court. You're going to have to deal with creditors regardless. And then in the average estate, as I mentioned before, 18 months later, you might finally be ready to have the hearing on your petition for final distribution, which is the action that actually allows you to remove money from the estate to the beneficiaries. So the California probate process is very court-centric. Most things of any substance require court approval or court at least letting them know. And so that's why it's so time-consuming and expensive, because we are involving the court much more than we are in other states and other jurisdictions. So what that is to say is that in California, if you own anything, a house, the smallest piece of land around here, if it has boosted your estate above that $166,500 level, you absolutely should have a trust instead of a will. And that's mostly what we're dealing with clients on a practical level. That's what I spend most of my time doing on the planning side, is putting together trusts for very average families in the Bay Area, 2 W-2 employees, they own one house, they have some retirement, they have some stock, maybe they have RSUs from their companies, that kind of thing. They need a trust. In other states, they wouldn't need a trust. They could just have a will and they'd be absolutely fine. The good news is the cost of a trust, a regular trust like that, is much less than what you pay even in court fees for the probate, or approximately the same maybe. So it is cost effective for many people to have that in place. But it's important for our clients who have these assets to make sure their planning is properly tailored for their situation, because people just don't know. When you go to LegalZoom or other places, you can get the documents, but you don't necessarily get the counseling, which is why attorneys are so very protective of the idea that they should be advising clients rather than LegalZoom, for example. Okay. So the reason that we want a trust, I've seen a couple questions and I think they apply to what we just discussed. I'm going to address them now. So the reason I say you should have a trust if you have an estate that combined total is worth above $166,500 is this. I'm going to put a caveat. If you've dealt with lawyers before, you know the problem. We always say it depends, but it's true. It does depend. When you own property in California, and let's say you're married, when the first person in that marriage passes away, almost everything can go to the spouse with very little inconvenience or difficulty. If things are joined as or owned as community property with rights of survivorship on the deed, it will pass automatically to the spouse. You do have to file some paperwork, but it's not a big deal. If you have joint bank accounts, again, you may have to do some paperwork, but it's not a big deal. There's a modified thing you can do with probate court called a spousal property petition. That's a one and done hearing kind of thing for any assets that you can't move automatically. You can get it done for very little inconvenience and expense. The problem is we're always planning for the worst case scenario. And unfortunately, not every married couple has someone who, sometimes married couples die at the same time because things happen. Sometimes one person passes away and the survivor never does their own estate plan because they don't have time to deal with it, or they just never get around to it. Now, when it's passing outside of the married unit, now you have to do a full-fledged probate unless you have some other structures in place. So I say this with the caveat that at the first death of one half of a married couple, probably the trust wasn't necessary. It does make it simpler when the second person passes away. So the reason for that is if you own a combined total property valued at less than $166,500,000, then you can use what's called an affidavit of small estate administration. And it's a form that you sign under penalty of perjury and get notarized. And you can take it to, Chase Bank and say, oh, you have an account worth $50,000. This is the affidavit that says who the heirs are, either under a will or just the intestate heirs. I am allowed to take control of this asset, or this asset needs to be distributed as follows. We swear under penalty of perjury, the total value of the estate is less than that number, and they will distribute it to you. It was designed as a workaround for people whose estates really don't justify the full probate process and who also don't have a trust. It can also be used with assets when you do have a trust, but you've accidentally left out some assets, which sometimes happens. Clients leave out a lot of times people have a checking account that all they do is move money in to pay their mortgage and household expenses. And sometimes they forget to put that in the trust. And as long as it's under that limit, you can use this for that. If you own any real property, if the real property is valued over $57,000, you cannot use the small estate affidavit, even if you're still under the total $166,000. So that's why I say the second you own any real property in California, you probably already need a trust to avoid probate. And the reason we want a trust is, again, time, expense, difficulty. No one wants to go to court. There's also some extra privacy with a trust, although many of the people who would otherwise inherit do still need to be informed, so you don't necessarily get full privacy there. There was a question about the death tax and the idea that there has been a proposal that they would eliminate the step up in basis at death. As far as I understand it, there's not a huge likelihood this law goes into effect. Keep in mind, of course, I'm not a professional political scientist or observer of Washington, so take it with a grain of salt. The difficulty is so much of our current estate tax system depends largely on that step up in basis existing, right? The reason that for most people they can receive an inheritance and enjoy the full value of it is because when the person who gave it to them passes away, they get the step up in basis as of the date of that person's death. So like for real property, for those of you who aren't maybe super familiar with this concept, if you have a house worth 1 million and your dad passes away and gives you the house, you get your tax basis in the house is 1 million. If you sell it 3 months after he dies for $1 million, you're not going to pay any taxes on that. You essentially got the value tax free as far as capital gains taxes. And a lot of our system is set up to pass wealth that way between generations. I think if we see changes, we may start seeing more lifetime gifting, because the idea will be, well, right now, the main downside of lifetime gifting is if you give the house to your son during your lifetime, he will not get the step up in basis. He will instead he will get the basis that you have in the house because he didn't pay market value for it. So that's why gifts at death right now are better from a capital gains perspective than gifts during your lifetime. If they change that law, I'm sure we will see a lot more lifetime gifting because it may be better to pass the asset earlier. It may help people minimize some capital gains taxes. It will also maybe have other effects. We might see more people allowing their house to be sold during their lifetime, so their estate pays the taxes on the sale, pays the capital gains, so that they're passing cash tax-free to their children. So we may see more lifetime sales. It's a complicated subject. We certainly don't know exactly where they will land, but it would be a huge change in the estate planning world. And I think it would fundamentally change the way we look at inheritance versus lifetime gifting. It might actually create a reversal of what we currently recommend. Okay, so Someone asked about the fact that someone has proposed a wealth tax for California. So it's, as I understand it, this has been proposed several times, specifically most recently, other than the time right now, back when they raised the estate tax limit so high federally. It's never managed to pass. It's never even gone to a full vote of the legislature, from what I understand. So it's something to keep an eye on. We certainly are keeping an eye on it, but there does not seem to be, at least right now, the political will to actually pass a California estate tax. Too many representatives presumably are from districts where people would lose a lot of value if an estate tax were passed on the California level. Okay, so I want to move on to the next one. And then I know we have some more questions that I will certainly make sure we get to in the presentation. Oops. Okay. Oh. All right, so I want to talk about Heath Ledger, because he had a very interesting situation. So he had a will, and in his situation, he probably didn't actually need to have a trust. Even though he lived in the US, his will was he had made one back home, and that's actually where I think his estate was probated. So he had made a will, and then he'd had a child, and he just never updated the will. So the original will left everything to his parents and siblings, as you might do when you are in your 20s and make a will. That's who you're probably going to leave stuff to if you're unmarried. And it named his father as the executor. Now, this story luckily has a happy ending. The family completely 100% agreed that what he would have wanted was for everything to go to his daughter. And so there was no dispute about that. They ended up gifting the entire estate to her. But there was some complication there. So the first is when you gift something as opposed to someone inherits it, there potentially are tax implications there. I think they were able to avoid that by using mechanisms that here we would, at least we would call disclaimer, where you basically say, I'm disclaiming my interest in the estate, treat it as though I never existed or predeceased this person. And eventually, because she was his daughter, and so she was in the intestate line of people to inherit, they were able to get the resources to her. But another problem was that because his father was named executor, and because obviously this was a high profile case, there was a huge blow up in the media. The father's brothers made public statements attacking his ability to manage the estate because he had previously served as the executor, I believe, for their father's estate, and he had actually been removed by the court in that proceeding. Now, I am not suggesting that very many of our clients are going to have their siblings attacking them in the media, but some of my clients have had their siblings attack them on social media, certainly, about their handling of the estate. Once the estate becomes public, once we are removed from the privacy of the trust situation, those details are out there, and anyone and everyone can comment. And I can tell you, and those of you who work with families in any aspect of this, you know, everything that's ever happened between those family members is going to come up, whether or not it relates to the administration of the estate. The time that Sally stole Susie's cupcake when they were 6, it's going to come up. It just is what happens in families. And everything I deal with in my practice is about families and about those relationships. So one of the things I make sure to stress, and I think it's important to stress with clients who are dealing with planning issues, is that vagueness is deadly in estate planning. You can't be vague. You can't try to spare people's feelings. If you don't want someone involved in administering your estate, you need to say so in writing, and you
All right. Did she freeze for anybody else?
Yeah, she did freeze. So it looks like her connection may have been stable. Not sure.
Yeah, she froze.
Let's see if she comes back. Oops.
She got cut off.
Yes, I'm going to see if she can see a chat. Well, it looks like her connection dropped altogether. Let's give it a couple of minutes, see if she comes back in.
Rick, is there a way that you can send her a text message?
Yeah, yes, I was going to try to do that. All right, she's back, coming back in, I'm sorry.
Not yet. She's back.
Yeah.
Well, I am so sorry, everybody. I was even telling Rick before the meeting started that at our office this morning, one of our attorneys kept losing internet while she was in court, which was pretty devastating. So I apologize for that. I will share my screen again and get us back on track. For those of you whose questions I didn't answer, I think you're going to have to resend them because I think my chat gets deleted when I get kicked out of the meeting. All right, so let's get back into it. Hopefully everyone can see my screen. Okay, so this is where I think I left it off, which is that it's not just about putting together a plan, it's also about getting the input and cooperation of key stakeholders in the plan, to use some corporate terminology when we're talking about a very personal subject. And that's why I think this FloJo is a really good example, because she had an appropriate estate structure set up, which was a will for the jurisdiction where she lived. What she didn't do, and what I have dealt with in the past sometimes, is she didn't tell anyone where the will was. They knew it existed. They could not find the original. They could not find a completed and signed copy. The estate was in court for 4 years because they couldn't find the documents. Her mother and her husband fought bitterly over what her intentions were, while everyone involved in the case agreed that they were going to, she wanted them to set up a charity. They could not agree on the structure, and there was no document to tell them who was supposed to be in charge of that. Eventually, the court had to appoint a third-party administrator, which costs money because there were too many family disputes in getting the estate sorted out. So it goes back to making intentions clear. And one thing that we tell people is, obviously, if you're going to appoint someone as your successor trustee, please send them a copy of your trust so they have a backup in case something happens to you. You know, things happen. A client called me today, actually this afternoon. She just moved and she can't figure out what box she put her estate documents in. And could I send her another copy because she needs them to set up her account at a new bank? So of course we keep a copy, so we happily send them over. But stuff like that happens. People lose documents. So it's important to get those other people involved and make sure your intentions are clear and shared in a widespread fashion with family members and other people who may think they know what you would have wanted when maybe they don't always know. Okay. I want to talk about Philip Seymour Hoffman because I think he's a really good example of someone who deliberately did not create an estate plan in the way he should have, for reasons that, frankly, in retrospect, are probably were not very sensible. So he only had a will, but he did it on purpose. He told his attorneys he, quote, did not want trust fund kids, end quote. His lawyers apparently sent him numerous letters and other communications in which they begged him to put trusts in place, but he didn't want to do that. So instead, what happened is he left everything to his partner, who was the mother of his children, and they paid a huge tax bill, because the estate was not structured in a way that would have avoided taxes. Again, we're talking about someone who was well over the estate tax limit, who with proper planning could have avoided creating trust fund kids while still using that money to support things that maybe he would have preferred rather than the federal government. I got to tell you, I've talked to clients a lot about estate taxes. It's something almost everyone is worried about in the Bay Area. I've never had a single client say to me, what I really want is for the federal government to get its fair share of my estate. I don't think we know anybody that is their primary estate planning goal, or even a secondary goal for that matter. So there were ways he could have put that money to better use. There are more complicated tax structures, trust structures available that will minimize or avoid estate taxes while still accomplishing whatever the person wants to do with them. There are charitable remainder trusts, which are really great for clients with a charitable impulse. They can be structured to allow certain beneficiaries lifetime use of the property, while ultimately having the principal go to a charity and thereby avoiding taxes on whatever is set off in that charitable remainder trust. There are other types of structures that can do similar things. There are lifetime gifting strategies that, of course, can accomplish similar things. There are a lot of options for clients who fall within that category where they need to be worried about this. One option that should not be an option, should not even be a consideration, is just saying, I'm not going to worry about it. I'll just let the government have its share and it'll be what it will be. That's not what we want to encourage people to do. So that's where I say the counseling part of the job is very important. And it's because people don't know what their options are. Even people who have teams of lawyers don't always know what their options are, or can't always maybe be persuaded to exercise those options. But at least those attorneys know that they did their due diligence in explaining to him why it was a very bad idea just to have a will, and to say, whatever will be, because that money, I'm sure, did not go to the purposes for which he would have preferred. The last example I want to give, and then I will open it up to questions and, of course, address any questions that have come in. I want to talk about Aretha Franklin, because she has certainly, and her estate was certainly in the news a lot. You may have read about it. You probably heard about a little bit about the situation. So she has a really interesting situation that kind of illustrates one of the problems we have, again, when we don't tell other people what we want, or we don't keep the estate documents in a safe place. So when she died, originally they thought she had nothing in place. And so it was going to go to intestate succession. I believe she had 4 children, so they would have each gotten an equal share. 1 year after she died, they discovered 3 separate wills, one of which was hidden under the cushions of a couch in her home. Why, you might ask? I don't know. I don't think anybody does. That's not the ideal place that we usually recommend you keep your will, in case anyone was wondering. Couch cushions is not the location I would suggest. 2 of these wills were dated from 2010. One was dated from 2014. All were handwritten wills that she had written herself. And as you might guess, all of them had contradictory provisions that made it very confusing about what she actually wanted. So they had to set a trial to litigate the validity of the wills. COVID, like it did for so many other things, delayed the trial date. They were supposed to go to trial over the summer. And because COVID delayed the trial date, this allowed for one final twist in the saga, which was in April of this year, one of the children produced yet another version of a will, this one unsigned but prepared by actual attorneys in 2018, which it looks like she just never got around to signing before she passed away, because she died later that year. And this is what I tell people when they say to me, like, look, I'm gone. I don't care what happens. They can do a probate. It's not a big deal. I don't care about the cost. Maybe the cost doesn't bother these clients. Going to court opens the door. It opens the door to random family members who have opinions. It opens the door to creditors who maybe wouldn't have the same open door in a trust. It opens the door to people who don't like what you've put in your will, and so think you should have put something different. And in Aretha Franklin's case, going to court opened the door. Her former sister-in-law filed a lawsuit demanding $43,000 to pay for caregiving services that she claimed she provided to Miss Franklin. Would that suit have been filed if they hadn't had to open a court case? Maybe. We can't perfectly guess, but I can tell you, I've had a lot of clients who, for various reasons, we had to go to court because the trust wasn't properly set up, or it wasn't funded, or something happened. And every time you open a court case, even the most benign type of court case, you've opened the door to something that can quickly spiral out of control. I know it sounds maybe a little bit weird that someone who litigates spends a lot of her time telling people, for the love of God, let's not litigate, but that's the reality. Clients don't win in litigation. Attorneys are very pleased by the outcome because you get paid by the hour a lot of times in contested litigation, but it's not a good outcome for the family. It's not a good outcome for the estate usually. I have, for example, I'll say this, I have clients right now who, the person who died created a trust. She did it through an online company, and then she took it to a notary to get everything signed. She was informed by the notary that the way she had drafted the deed to move her house into the trust was not the proper way to draft a deed. And the notary was 100% correct about that. The notary offered to draft this deed for her for what is probably a reasonable fee. She didn't want to pay the money to have the notary do that. She died a little bit of time later without ever having resolved that issue. So her heirs said, okay, what can we do? Because we have a valid trust, but it wasn't properly funded because the house was never moved in. And the house is the main asset. So there's a special kind of petition in California called a Hegstad petition that you file that basically says, sorry, Your Honor, we really meant to fund this trust, but we just couldn't get it together. We just forgot. We meant to do it, but it just didn't happen. We filed one. Some other family members came out and said, well, we don't think the trust is valid in the first place. And look, there was no other option. We had to open the door, but it's been a couple of years and the case still is not resolved. And a Hegstad petition in theory takes 30 to 60 days to be resolved if everything goes perfectly. So once you open the door, you can't close it again very easily. And you often find yourself paying people who maybe don't deserve a share of the estate because the cost of litigation is going to be higher than the cost of buying them off, for lack of a better word. And so that's why I usually counsel clients, make this as airtight as possible. This is not something in which you want ambiguity. All right, I am going to pull up, I saw some questions. Yeah, let me do that. I think we have some tax questions. Okay, so co-executors. This is a really good question. So someone asked, David Hamilton asked, having co-executors with equal power a good idea or a poor idea? I usually recommend against it. And the reason for that is it has never been easier for two people to make a decision versus one person to make a decision. And in estate law, as with many things, having a clear decision is better than, having a clear decision is what we want. Whether it turns out to be the right or wrong decision, obviously you want it to be at least a little bit right, but it's better to have a clear-cut decision maker in place. Clients say to me all the time, well, you know, my son and my daughter, they get along really well. I'm sure they'll be fine. People who get along really well can disagree about the best course of action for something. And when it comes to signing authority over accounts, when it comes to who has the legal authority to decide which property gets distributed and how. When it comes to who has the responsibility for dealing with creditors and other people and doing an accounting, it is better to have one person with the clear-cut authority than co-executors or co-trustees or co-power of attorney agents. The only place where I don't think it's as problematic is with a healthcare directive. A lot of people want all their children to be co-agents on a healthcare directive. You are going to potentially have disputes between the children, but because it's not involving money, you don't often have to have such a clear-cut decision-making trend there. Although that being said, I always strongly advise against having co-agents for any of these things. Because this is the bottom line, if somebody doesn't feel comfortable or they just don't have the bandwidth to take on that role, they can resign. They can delegate other people to have certain authority. There's nothing stopping a executor or a trustee from saying to their sister, can you help me clean out the house, even though I'm the trustee? Or what do you think? Should we sell and each take 50% of the profits, or should we keep the house and rent it out? They can ask for input, but at the end of the day, you want one person who's going to have the final say over what should happen. You can do it though. Legally speaking, there's no bar to it. I just don't think it's a good idea for most families. I think instead of removing conflict, you've instead created more ground for conflict, which is never what we want to do with an estate administration.
Jennifer, I don't know if there's any other, I mean, I have some questions, but I don't know if there's any other folks that have questions in the
Yeah,
in the chat.
There's a question in the chat about IRAs. About them being creditor protected, excuse me. Okay, so the question is because retirement assets are often creditor protected, should they be distributed first in estate planning? It's an interesting question. So I will say we oftentimes treat those assets differently when we're putting together an estate plan. And what I mean by that is because those pass by beneficiary, they are automatically excluded from probate unless there's a lapse on the beneficiary. For example, you've listed only one person and they have predeceased you, and now we have to basically get someone appointed as the beneficiary through the court system. So for a lot of purposes, the retirement assets are treated as their own thing, where what we're doing is making sure that the beneficiary designations are up to date, but we're not actually including them in the written estate plan. That being said, there are some situations where we are working them into, for example, into a trust. If you have minor children, if you give them a share in a 401k or an IRA, it's going to have to be held by a custodian for them until they reach the age at which they can receive it. And in California, that often means you're going to have a guardian of the estate for the child appointed by the court, which subjects that person to court monitoring potentially. Again, time and money and frustration. So for minor children, especially when they got rid of the stretch out provisions, and for anyone who isn't familiar with that, it used to be that we could stretch out the distribution of an IRA even through a trust structure, as long as we structured the trust in a way that it was basically passing through the trust to the equivalent of a subtrust, that was the beneficiary and the subtrust were treated as like the same person for the stretch out rules. When they got rid of that a few years ago, gosh, it has been a few years, yeah, at the beginning of 2020, I believe. When they got rid of that, it almost became irrelevant whether it went to an individual or the trust, because you couldn't take advantage of the stretch out anymore, except in very specific situations. So we've done a lot more of directing those retirement assets to the trust as the beneficiary for distribution purposes, rather than to the individuals. Now, there's a very valid point about the idea that if those assets go to the trust, they're now available to creditors in a way that they wouldn't necessarily be if they stayed as inherited IRAs or 401ks. most trusts have creditor protections built in, especially if they're for minor children or other people whose shares are being managed through the trust for a long period of time. It doesn't mean it's perfect. I'll put it this way, it's not a bright line rule. There's no rule that says like we should keep those two assets separate or we should have them be commingled within the trust. There are some advantages to keeping them separate for adult beneficiaries. But on the other hand, for especially minor children beneficiaries, or if you have a special needs trust or anything like that, we're going to have to pass that asset through the trust to properly distribute it according to that person's will and avoid the necessity of guardians of the estate being appointed and dealing with the court structure there. So they shouldn't necessarily be distributed first, but we should take a careful look on how we incorporate them into the trust structure, if at all, depending on specifically the circumstances of what types of beneficiaries you have and what their needs might be. Good question. I'm sorry, you said you had some questions as well.
Yeah, it's John, yeah. So the first question is, I recently, I'm married and have children and so forth, and we recently updated about a couple of years ago our living trust. We used to have the old traditional 20 years ago AB trust, and then also the separate asset trust, so that they were like 3 different trusts. We now just have one combined trust, and then we have schedules that then say which are joint and which are separate assets under the husband and the wife. My question is, as we get additional assets or open additional accounts and so forth, should we be periodically updating that schedule? And if we do that, do we have to have that schedule notarized?
Really good question. So first, thank you for opening the door about AB Trust, which I'm going to come back to in a second because it's something that I feel very strongly about. With schedules of property, and I don't know exactly how your attorney drafted this, but at least the way I do it, they are separate documents than the declaration of trust. And the reason I do it that way is because they are designed to be periodically updated, not necessarily by the attorney. I think a lot of attorneys have moved these days to allowing people to update those themselves. We send like a soft electronic copy of those to clients when we're done with their estate plan, so they can just generate a new list for themselves if they want. I would say this, especially if you have some assets that are community property and some assets that are separate property, I would keep those updated, because especially if you have different distribution provisions, we need to be very clear about what belongs in what category there. It's different if you have a couple where everything is community property and it's one set of distributions. If so, and you accidentally don't add a bank account, but it's under the name of the trust, fine, they'll figure it out. But when you have especially different distributions for different categories of assets, then yeah, keeping those lists up to date is important. So there's no confusion about what category one was intended.
Got it.
For notarization,
yeah.
Yeah, I would say this. There's no legal requirement they be notarized. At minimum, I would keep a printed version and at least sign it and date it.
Yeah.
If you think there's going to be any controversy about the categorization of an asset, you should absolutely have those notarized. Okay. Because that's the only circumstance in which I think you would need it, is if somebody says, I don't think that mom intended for that account to be her separate property. I think it was supposed to be community property. At least then we have the thing that mom signed that said, yeah, this is my separate property.
Right.
So that would be my recommendation there, but they are designed to be periodically updated, and I do strongly recommend those be kept up to date. It also, on a practical level, and this is not something we used to worry about, I don't know about you, but I don't actually get paper bank statements anymore for most of my accounts. It used to be, that was one of the main ways that the successor trustee discovered what assets belonged to the trust and what they had to deal with, was they would check the mail and they would go through someone's filing cabinet. We don't have those anymore, and email and electronic access can sometimes be tricky. And so keeping those lists up to date at least gives the successor trustee a starting point of identifying which institutions they have to contact. So I do think it's important to keep those up to date.
So before I ask my
Just very
other
briefly about
question,
AB.
yeah, I was going to let you talk about AB trust, and I have some other questions.
Sure. So just briefly about AB trust, in case anyone is dealing with clients who have one or you have one yourself. They're not wrong. They're not legally incorrect. If the estate tax changes dramatically, we may all go back to doing AB trusts. But right now, for our purposes, you lose a lot of flexibility with an AB structure that you may not want to lose. And the reason I say that is people's spouses can sometimes survive them for decades. And when you have an AB trust, at the first person's death, you've locked in a portion of the estate into part of the AB trust that, number one, may or may not be accessible to the surviving spouse. It depends on how the trust was drafted. Number two, for tax purposes, has been locked into a value as of the date of the first person's death, which is great for estate taxes, but not great for capital gains if you'd like to take advantage of the double step up in basis that you can get for property from a married couple. And you just lose a lot of flexibility to respond to changing circumstances that can exist. There are still families for whom AB structures are appropriate. Blended families oftentimes need an AB structure to make sure there's no concerns about children from different relationships being cut out of estate plans. It's understandable. But there are a lot of advantages to the type of trust structure that most people now have, which is a structure that remains almost fully flexible until the second person passes away. So for old AB trusts, I'm not saying you need to get rid of them, but I am saying if you still have an AB structure and you haven't talked to your attorney lately, it is a good idea to check with them and see if it still makes sense for you to have one. You can also get the attorney to change it so it's a optional AB structure that can be elected at the first person's death. That way you're not locked into the structure, but you also have it available in case you decide that you need it. But right now, at least the way the tax picture currently is, I think AB structures offer a lot of disadvantages that are not outweighed by the estate tax advantages for most families.
So in the case of an AB
Sorry,
structure,
go ahead.
in the case of AB structure and somebody, well, I'll use my mom as an example because my dad passed away a number of years ago. They have an AB trust. So so I know that the whole concept of you losing the step up again for my dad's piece of his piece that are in trust. So is there a way to unwind this? Or is that a big hassle? It'd be hard to argue and do a reversal? Because I've heard about that too. I don't know how much effort's involved with that.
There can be substantial effort, especially if, and this sounds really counterintuitive, if people did what they were supposed to do when the first person passes away, it's actually harder to unwind it.
Got it.
I've had clients who did everything they were supposed to do, including, informing the IRS, properly electing to move that share over, getting an EIN number sometimes for the subtrust because it's its own entity. They did all the things they were supposed to do. Now to actually unwind that is going to be a hassle and will likely involve dealing with the court.
Okay.
For people, I've also had clients who didn't take those steps because sometimes they didn't know they were supposed to. Mm-hmm. And because they actually never administered the trust, unwinding it can be as simple as amending the trust with the consent of every beneficiary who would be affected by the amendment, which is basically everyone who's a beneficiary. But because no steps have been taken, it's much easier to do that process. Now, not all attorneys are comfortable doing that. And some attorneys will say, you absolutely can't do anything after the first death. I don't think that they're correct legally. I do understand some of them just don't think that it's worth the risk of lawsuit. So, mileage can vary on what attorneys will tell you about that, but you can do a lot of things with those structures with full consent of anyone who would be affected by it.
Got it. And you mentioned that the current rules sunset in 2023. Isn't it 2025 or is it 2023?
Oh, I believe it's 2023, but it's always possible that I am saying you're wrong. I don't think. Let me double check that. I've been saying 2023 for a while, so I hope I haven't been saying the wrong year.
Unless it's different from the tax rates and so forth, because I thought it was 2025, but I may be wrong too, so.
No, nothing is loading. Let me check on that and get back to you in a second about it.
Sure. Okay, so.
Go ahead, I'm sorry.
Okay, so let me give you an example of, and I think I just want to confirm my understanding and that is correct. So right now on a joint situation, it's $22 million, right, for the exemption. And let's say
Approximately.
let's say somebody gifted $20 million out of the 22, and the law changes and it goes back to $11 million, say. Then my understanding is that there's really no clawback issue involved. But if it drops back to $11 million, you've already gifted 20 million, you've more than surpassed the 11 million. So you can't do anything more beyond the $15,000 a year. Is my understanding correct?
Yeah, so that's a really good question. So yes, well, with the caveat that in theory, the legislature, I guess, could write a law that somehow said actions taken before, can be undone, but they wouldn't write the law like that because it would absolutely end up in court. So yeah, generally speaking, the steps you've taken before the law changed would still be valid steps. But again, depending on how the law was written, you probably would not be able to make further changes in that scenario, or not be able to make further estate tax. You wouldn't be able to use gifting basically as a strategy to avoid the tax under that scenario.
Right.
Assuming all those variables were in a row. On the other hand, a recent example in a slightly different arena, when they changed, as you probably know, they recently changed Prop 19 with the parent-child exclusion.
Right.
So they actually said, the parent-child exclusion, but also the transfer of your property tax basis between counties. They have said, or at least the current guidance that they've released says that if you had already used your age 55 and older exemption to move, you basically got it for free. You still get the 3 exemptions that you now get. So sometimes they write the laws where they basically say, well, whatever you did before doesn't count against this. But I imagine they would not. I imagine because you would have to report the $20 million gift to the IRS that they could track that. I would imagine that it seems to me to be likely that no, you would not be able to then do an additional gifting once you've used up your exemption already.
That's my understanding in reading the law and so forth. So let me give others an opportunity to ask questions. I have a couple others, but I don't want to monopolize the questions.
John, go ahead. I don't see any other questions in the chat.
Okay, all right. So this is really involving a client of mine that one where I did the 706 form and so forth, and the executor, who's the older brother, decided not to take any fees. So I assume that there's really no requirement that the executor take fees, correct?
No. And as you probably know, a lot of times clients don't, because the fees are counted as income versus the inheritance is not. So especially in, like, I've had cases where there was a sole beneficiary who was also the executor. They don't take fees because they have to pay, they may have to pay taxes on those because they're counted as income.
Right.
So yeah, no, there's no requirement that you take executor's fees. You can always waive those.
Okay. And then another client whose husband.
Now, if you're asking if there's a requirement that your attorney takes fees, I'm going to tell you that no, but attorneys usually can't waive those fees.
Got it. So I have another client that the husband passed away, so I advised them, and the person, they own real estate. So I said, you really need to get an appraisal. So I assume you will always advise get an appraisal rather than just having your real estate friend do some comps and so forth, but to actually pay and get an official appraisal. Do you recommend the same thing?
Yes, the cost of appraisal versus the value of the real property is so minimal. I don't mean to diminish the fact that estates can be very expensive, but we're talking like you can get an official appraisal done for a few hundred, maybe 1,000 if it's especially complicated kind of property. You want something that is going to stand up to IRS scrutiny if they ever have an issue with it. And your friend pulling some comps from the MLS is not going to cut it. So yeah,
That's
you
why I
want
advise,
something that the professional is willing to spend behind.
yeah, well, that's how I advise them. So
Yeah,
I'm
that's
doing
good
the right.
advice.
And then what do people do if you have jewelry and furniture and stuff like that? I mean, you don't bother getting appraisals for that stuff, right? I mean, I don't. I mean, maybe furniture you don't bother, but I don't know about jewelry. Do they just end up if the jewelry's been tagged and say, I want this piece to go to my daughter, I want this piece to go to so and so? I mean, who's going to really track that? I guess.
Yeah, so this is a really good question. And the answer is probably no one is going to track it. What I tell clients is this, and this also comes into the determination whether or not we list those items as belonging to the trust or not, because they obviously don't have titles of ownership usually.
Right.
So if collectively or individually those pieces are of high value, then yes, someone should be tracking it. Someone should be, in theory, getting those values. And I define high value by, number one, if you would have to get an extra insurance policy on them, then yes, they should be. And also, I think we all know around here, there's a lot of clients, for example, with large amounts of jewelry that maybe the pieces individually are not high value, but collectively they really are. So those kind of things, we probably, I'll put it this way, probably those should be valued in case there are any questions. Now, if you are sitting at $9 million, that would have to be quite a collection of physical items to push you over the estate tax limit.
Right.
So I wouldn't worry about it in that scenario. But if you're sort of within 100,000 of it, you probably should get some valuation so that you can make extra sure that they're not going to claim that you owe taxes based on those items. It's the same in probate though. Even when we have physical items, they're supposed to be distributed according to the terms written out in the document, but the court isn't necessarily monitoring every step of that process as long as they eventually get pushed where they need to go. Same with the small estate affidavit. You can still generally use it even if you have physical items, unless there really is a strong claim that somehow that's going to push you above the value. And for most physical items, we look at garage sale values. Like with furniture, there's just not a huge market for secondhand furniture, and except outside of very rare exceptions. So stuff like that, you can basically say it's worth a few $1,000s and call it a day. But jewelry, art, sometimes cars, that kind of thing, those are things that you may need to get a written valuation, especially if you're close to those caps in any of those categories.
Okay.
And I think Armando had a question if he's still on. I want to make sure I don't forget about him.
No, I'm here. I'm here. Hi. Thanks for giving me a little bit of time. Here's my scenario. It's my dad's estates. My mom's in heaven already, and I'm one of 3 children. And, my understanding is that the properties will be divided equally. So the properties on the beach, and my dad lives in one, and we have 2 rental properties. So my sisters, one of them doesn't have any children, but my older sister has 3 children. 2 of them are in properties, and they're paying approximately 10% of the rental value. Sure. So here we go. I mean, when that day comes and we have to decide what we're going to do, I'm concerned that they feel maybe grandfathered into these rental properties. Well, my other sister is saying, yes, we got to, they can pay market value rents or they can move. And the issue is that my older sister with the children that are in those properties, she had a stroke. So she's basically incapacitated. So it would be easy if both my sister would say, this is what we're going to do. However, now I'm dealing with my one sister who were in agreement about what we believe should go forward. But my other sister, the grandchildren are in the property, and I'm kind of wrestling with the idea, are we going to run into opposition? I'm sure we will, but what is your quick advice on this type of scenario?
Yeah. So this is unfortunately not an uncommon scenario. A lot of people have children or relatives living in properties at a below market rate, which was fine when that person was alive, because they get to make their own choices. But when they pass away and now there's new owners, obviously for a lot of people, that scenario is not going to work. So what I will say is this: I don't know who the trustee or executor who's going to be appointed is. A lot of this will depend on who that person is, because that person has most of the power in this scenario. Now, that power is bound by the idea that a trustee or an executor is a fiduciary, which means they have an obligation to the current beneficiaries of the trust or the estate to do what's in their best interest, which means that, and I know this isn't likely because you said she had a stroke, but if it had been your other sister who was the executor, she couldn't allow her children to live at less than market rate in the properties just because she felt like it, because she would have had a fiduciary obligation to you and your other sister to maximize the value of the trust or the estate. Now, on a practical level, whoever's going to be in that position.
I am the executor.
Okay, so you would be the decision maker then, and your responsibility is, it doesn't sound like there is a trust, or there is a trust.
I believe there is, but I'll have to get to my father. I'm not.
Yeah. So when you begin administration as the trustee, one of the things you have to do is take control, or as the executor, to take control of the property. Doesn't mean you have to kick anybody out right away, but you would have to start with making decisions about what the disposition is going to be, whether that's they're going to be rented and the rent is going to be split, whether that's the properties are going to be sold and the proceeds are going to split. Keep in mind that even if an estate is divided into thirds, not every single asset has to be split into thirds. You can do some horse trading within there. Mm-hmm. So oftentimes some of these issues are resolved by, let's say, best case scenario, every single property had identical value. Each person could get one. I mean, like, there are different things that can be done. Right. But strictly speaking, you actually have a responsibility to not let those properties be rented at below market rate to somebody unless the other beneficiaries at that time agree that that's okay. So it does become the responsibility of the trustee to say, you either have to pay rent, or you have to leave because we're going to sell them. Whatever the decision there is, it actually is legally required in a weird way, that unless everyone agrees on a different course of action, that you actually make those assets maximize their value by sometimes removing family member tenants, or at least asking them to pay what you could rent it on the free market for.
So them being rental properties, there's more value in having them stay rental properties versus selling them off. So do the grandchildren of my sister who is incapacitated, do they have the right to say, hey, you need to sell the properties now so we can distribute the money amongst the three parties?
A lot of the rights depends on whether they are a current or a future beneficiary. If, for example, it's 1/3 to each of the siblings, then what their children want is completely irrelevant, because they're not the beneficiaries at that level. They only become the beneficiary if their parent predeceases them, usually. Again, depending on how it's structured. So their wishes are actually irrelevant in that scenario. That said, if, for example, your sister said, well, I want the properties sold, and you said, well, I want the properties kept, as the trustee, again, depending on how the trust is written, usually have the final say On the other hand, you do have to weigh it with the practical consideration of, do I want to have to deal with somebody who wants the property sold and they're going to ask me every month, when can we sell the properties? Like, sometimes we end up with, we'll call it buyout scenarios, where someone's interest in the trust is actually bought out because the people who want to keep them as rentals don't want to deal with the people who want their assets converted to cash. Again, all of this depends on what the trust itself says. If the trust itself says the assets need to be liquidated, then unless everyone agrees they need to be liquidated. If it says they need to be kept as rentals, then unless everybody agrees they need to be kept as rentals. If it just says that they need to be distributed, then if they're going out of the trust, then they go to the owners, and those new owners then have a right to do something called a partition action if they really want to force the sale of the property. So it depends largely on the terms of the trust. And if you have questions, if you speak to your father and you really do have some questions you want to discuss, I'm happy. I think my email and phone number is there. I'm happy to have a private conversation about that. But so much of this depends on what your documents say.
All right. Okay, perfect. I mean, you gave me enough to follow up questions. I see my father in 2 days, actually. So thank you.
You're welcome. Thank you for the question.
Jennifer?
All right, I think we have a few minutes left. I don't know if you have any questions. Otherwise, we're good.
I'm not seeing any more questions in the chat. The participants are welcome to ask, or otherwise we can conclude. We have had a number of people drop off. So maybe we'll conclude and we'll distribute the recording. I want to appreciate everybody who stayed on to the end. And
Sorry about the technical difficulties. Thank you for being patient. And I will, at minimum, send out, I don't think the PowerPoint is going to be terribly helpful unless you want to see pictures of celebrities, but it has my contact information, which I'm happy to share. And if anyone has something they didn't want to ask in front of everybody else, please do not hesitate to call me or send me an email. I'm happy to have a private conversation.